What is dispute resolution for athlete-agent contracts? Imagine a disagreement between an athlete and their agent that could threaten their career or financial future. How do they settle it without chaos? That's where dispute resolution comes in. When conflicts happen over contract terms, fees, or duties, they need a clear way to be solved. Dispute resolution involves legal processes designed to handle these issues fairly and efficiently. It helps athletes and agents avoid long, costly court battles and keeps their professional relationships intact. One common method is negotiation and mediation. These are informal talks where both sides try to find a middle ground. Sometimes a neutral third person, called a mediator, helps guide the conversation. Mediation is popular because it's faster and less expensive than court. It also allows both parties to keep control over the outcome. If they can't agree this way, arbitration is often the next step. Arbitration is more formal, with an arbitrator or panel who listens to both sides and makes a binding decision. Many athlete-agent contracts include clauses that requiring disputes to go to arbitration instead of court. This process is private, and the arbitrators are usually experts in sports law, which helps make informed decisions. Some sports organizations have their own internal systems for resolving disputes. These might involve review panels or committees that look into complaints and try to settle issues before they go outside the organization. It's a way to resolve conflicts quickly within the sport's own rules. If these options don't work, the last resort is court litigation. Courts can enforce contract terms, award damages, or issue orders to stop certain actions. Legal clauses in contracts are very important. They specify how disputes will be handled, such as requiring arbitration or designating a specific location for resolving issues. Laws from sports federations, state governments, and sometimes federal authorities also shape dispute resolution options. These regulations often set rules for licensing agents and how they must behave, which can influence how disputes are settled. Fairness and confidentiality are key. Dispute resolution processes must give both sides a fair chance to present their case. Arbitration panels often include sports law experts to ensure decisions are well-informed. Confidentiality protects sensitive contract details and financial information, which is especially important in sports and entertainment industries. For athletes and agents, understanding these options is essential. Reviewing dispute resolution clauses during contract negotiations can prevent surprises later. Using mediation or arbitration can save time, money, and preserve professional relationships. Knowing the internal dispute mechanisms of sports organizations can also offer quick solutions without involving outside courts. Having legal counsel experienced in sports law is a smart move to navigate these processes smoothly. In the end, dispute resolution for athlete-agent contracts is about finding fair, efficient ways to settle disagreements. It balances the interests of athletes and agents while respecting the unique rules of sports law and athlete rights.